webinar is with none other than Felicity, and guess that disappeared for a few seconds there. Felicity, welcome back and thank you for joining our webinar. How are you doing today?
I'm fantastic, thank you. How are you? I was just sharing it live to my Facebook page because I haven't done that before.
Wonderful. I done exactly the same in the countdown. No, wonderful. Thank you very much for that, Felicity. Felicity, we all know the theme, we all know the narrative, we all know why we are online today to discuss about child maintenance difficulties in South Africa. I'm certain people know what I've been up to, day-to-day activities in and out of court. Felicity, what have you been up to for the last 2-3 months since we last chatted?
Excuse me, I got horrid flu and then it went to bronchitis. So I didn't really have a voice, and yeah, it really kind of knocked me a bit. So I was doing a bit of healing, but yeah, almost over it. Little bit of a lag. Thank goodness it wasn't COVID. I did have a few scary moments there, but and other than that, I've been working in the background on my research and on the Facebook group and writing articles and doing a bit of coaching.
Yeah, that's something I wanted to discuss with you later on is regarding the coaching, and I think it's a very invaluable tool for anybody, but we can touch on about it a bit later on. But Felicity, on the issue concerning you being ill, Felicity, you like weed, you cannot be damaged, you're tough. It will take more than a flu or something to that effect to slow you down. So I'm happy. Felicity, awesome stuff. I'm glad we're online today and we're going to make it happen today. Child maintenance difficulties in South Africa, that is the topic of discussion. We accept that. I think today we can discuss the issue concerning whether or not it's necessary for a person to have a legal representation in a child maintenance matter. And remember, child maintenance matter has very many facets: the application, the first time inquiry, and the trial before the magistrate. So it's a lot of aspects. And if it's necessary or if it's advisable, and the question is, at what point is it necessary and advisable? Or is it not necessary and advisable at all to have legal representation in a child maintenance matter? Felicity, what is your take on that specific issue?
I think that the Maintenance Act is constructed and written essentially for the layperson, one to get a basic idea. There's a lot of legal references but if you bypass those, it is pretty much understandable to the layperson. And I think with that in mind, it was that people don't need legal representation generally for maintenance matters, because we know this. There's precedents where in High Court, Court of Appeal and Constitutional Court where they have stated that the maintenance courts are there specifically to deal with maintenance matters, but also they're structured to be able to act in the best interest of the child. The MOs, the maintenance officers, have LLBs, and if it goes to trial, the prosecutor is actually there to be essentially the child's and your legal representative. And the magistrate is meant to be unbiased and make a ruling that is fair and just based on the evidence presented in front of them. So I think by and large, if people know the Maintenance Act or the basics of the Maintenance Act, and they understand court process and the functions of each person at court, they can quite easily represent themselves, even if the defendant has a legal representative. I believe that if you have enough knowledge, that you can still represent yourself. And also that most people who are accessing the maintenance courts are essentially financially limited. So it's not always possible to go and get legal representation because, it's a profession and they're not cheap. So I think by and large, women can represent themselves, and men, if you acquire the knowledge and you have the emotional capacity to stand your ground, remain calm, and focus on the issue, I think, and the proof is actually on the group, that you can be successful.
Felicity, I'm with you 100%. I believe it's not necessary for a person to have legal representation in a maintenance court matter. I will not discount the benefits of having legal representation. So the difference between necessary and not being necessary, because maintenance officers and the maintenance court are two different forums. So the inquiry taking place before a maintenance officer is X, Y, and Z. They try to mediate the matter, they try to assist the parties. But when it comes to the actual hearing or trial in front of a magistrate, the law of evidence and etc. comes in. Of course, they have an obligation. So I would say initially when you apply for the maintenance, make a maintenance application, and you've done your research, you know what's relevant, you know what's necessary, you know how to prepare your documentation. At that specific point, it's not necessary to have a legal representation. The data online, the data on the internet, the services you offer, etc., or consulting with a lawyer before the time can assist you in launching your own child maintenance application without legal representation to assist you. So that's fine. I accept that. If you're not willing to do all that homework and the hard work, etc., in making sure your application is solid, then obviously get a lawyer. I mean, makes logical sense. And Felicity, if the one is not like you, I mean, you are a hardworking person. I'm certain you can handle a maintenance matter on its own, any court matter on its own, because you have the tenacity and that will. But if somebody, as you mentioned earlier, does not have the emotional strength to deal with these type of things, Felicity, on many occasions, I ask a client a simple thing: fill in this form for me, and they fill it in such a apathetic and a nonchalant manner. No matter how much I explain to them how important this is, it's almost like they're saying, I don't want to. You lawyer, they're not saying they're being insulting to me, but they're not willing to put any energy into the specific, activity. So that's the one aspect. When you appear the first time before the maintenance officer and you have done your research, and then of course you can present your own case there as well. You can present to the maintenance officer, this is my income, this is my expenditure, and the maintenance officer has the obligation to assist and try to mediate and resolve the matter. But if the other party, or for example, if the parties have very intricate financial affairs, we're dealing with trust, we're dealing with policies, we're dealing with a whole load of things, then it might be advisable to make use of legal representation at that specific point. I'll deal with the trial a bit later. Felicity, what's your comments on
that? Absolutely. I think that a very small percentage of people have complex matters, but they do exist. And the grey areas in the acts, like fair and reasonable, is open to persuasion. Okay, and if you don't understand how to how the legal representatives think and argue the matters based on years of experience, it can be to your detriment. And as you alluded to earlier, is where there has been some kind of abuse and it still is continuing post-relationship, and you do not have the emotional capacity to actually face that person, be in the same room, even more so if they have a legal representative, because emotionally you just don't have the capacity, and you get triggered and you become emotional, and you forget and you get stomach aches and headaches, all of those kind of symptoms. I definitely recommend that even if you have to borrow the money or come to some kind of an agreement, that you do get a legal representative, because in a hostile environment like that, it is very important for your mental health as well as for the outcome to have somebody there who is impartial, that can be your barrier, and to protect you from further abuse. Because I know that from my own experience and many other people, that it can be a simple thing like one look from the person, and it triggers you, or because you remember that as being a warning, don't you dare speak anymore, because of what is going to come after us. And if you're sitting in a maintenance officer's office, or even in court, and you get that look, for example, or a particular gesture, it triggers you, and doesn't matter how well composed you are, you can lose your composure, and it's to your mental and detriment and to the outcome of your case. And then I definitely advise people to get a legal practitioner, more so one who specializes in family matters and one who understands the dynamics that really is there as your person. Because I've also heard so many stories where they are legal practitioners, but they don't specialize in family matters or maintenance. They might do conveyancing or whatever, and they've done you a favor because of somebody who you know, or they're giving you a special price, whatever, I don't know. And they don't understand the dynamics and all the nuances. So they don't pick up these underlying things. So sometimes it's not always good to go that route. Rather try and get somebody who's like yourself, like Aisha, Wendy, Nikki, Nasli. I mean, I can name a whole host of amazing legal practitioners who specialize in family matters, who I know from references where they have felt safe and protected, and they've got good outcomes.
Thank you for that, Felicity. Felicity, also on the same note, if you have as a client or a complainant, put it that way, or respondent, if someone is claiming maintenance from you, many times that happens, and the process is also very overbearing. If you have a very minimalistic attitude on the case, like I do not want to do much, I'm lazy, you know. Many people they need to file a maintenance application. But all that they want to do and all that they believe they should do is to stipulate the bare minimum, and they do not unpack anything. And they believe in their minds that that they are a victim, and that the courts, by them appearing in front of the courts will automatically give them exactly what they want, despite any efforts on their side. And that's very concerning. I say it all the time. It's like, I'm a victim. The father is only paying 10,000 maintenance per month. He should be paying 50,000, and therefore, you know, I file my application, they do not even provide relevant information, you know, the father's address, scratch a line through that. You know, how will the maintenance court even process an application? The ID number, they don't provide the date of birth. So where I'm going to with this, Felicity, is if you have that attitude, you should not have that attitude in a maintenance matter. But if you have that attitude, please make use of legal representation. If you're willing to learn and develop yourself and develop a skill and fight your own case, save a lot of money in the process, then of course make use of legal representation.
Absolutely, because you know what people don't realize is that if you go unprepared, whether it's by yourself or with a legal representative, and it ends up with a magistrate or in a maintenance officer, and you agree to an amount, okay, or if you don't agree and you go in front of the magistrate and an amount is determined, and an order of court is made, you've got to wait a minimum of between 6 months, at least a year, before you can apply for an increase, unless your circumstances change fundamentally before that. And so if you could have got 3,000 Rand, but you accepted 1,000 Rand, not realizing that if you've done your documents and you declared all your expenses, you could have got 3,000 Rand a month plus school fees or medical aid or whatever. It is to your own financial detriment. So it is incredibly important to be prepared, whatever it is. I mean, I say to my clients that you need to think of it as like you're selling your house. Okay, so when you put your house on the market, you will put it at a slightly higher price because you know you're going to get negotiated down by the buyer. So I use the same analogy with maintenance. You put every single expense down, and then you kind of highlight the ones that you're prepared to negotiate on, to remove, to come to your baseline that you're prepared to accept. So just like a house, your initial claim is valid. I'm not saying you make up figures, but your amount is valid. It includes every single costs incurred, but you know you're going to be negotiated down. So before you even go, you have an idea of which ones you're prepared to negotiate on, to take you to your absolute minimum that you really require to be able to provide for your children. That is fair and reasonable, because it is a negotiating process. I mean, I've been through it. The maintenance officer will sit there and interrogate your evidence and go, oh, but why are you buying Lux soap? Maybe you should buy Lifebuoy soap or something, you know, the local brand, or you need to move home and get a cheaper accommodation. I mean, there is all of this banter, and also the defendant does exactly the same, you know, but you can't eat out once a week, you must eat out once a month, whatever it is. I mean, I'm just using these as examples. So, and that's part of your court readiness, and also knowing what to expect. So you are better prepared. And it's a partnership, whether you've got a legal representative or not. I still think that it's a partnership, that the more involved you are, the better your outcome is, because you aware and you develop this rapport with your legal representative. It's not like trying to extract everything out of your clients, you know, that because you've been working as a partnership, you have developed a method of communication. That if, that, for example, if you now interrogating and you look over to your client and she gives you a particular look, then you will find an excuse to just get clarification or something, because you've worked together, you're a team, and it does work better for both of you.
Felicity, I'm with you 100%. Felicity, I've been doing this for many years, and the best results I get if I do represent a client is a client that works with you. You know, is a team player. Because what often happens is clients are not team players. They do not work with you. They almost like, I'm paying you the money, not in a disrespectful manner, but I'm paying you the money, so make magic happen for me without my effort. For example, I done a maintenance matter quite recently. I got briefed very late in the specific case, and I couldn't, consult very well with the client, but I had to appear in the court for postponement. So the court asked me the question, what type of work does the client do? I had a vague understanding of what the client done, but I have requested this question from the client previously in correspondence. I went to my files. So the client intentionally didn't provide me with that specific data. So I obviously could vary it and query it, but the client wasn't working with me. You put an effort to obtain certain information from the client, give the client questionnaires, etc., fill it in, complete it for you, so that you can make your life easier. So you have to go across the reference or something. What we're trying to go with this to Felicity is a lot of money can be saved. Still a lot of money can be saved, and a lot of anxiety can be saved if you work with the other people. You work with the maintenance officer. You work with the system. Don't work against the system. So Felicity, maybe I can now touch on the issue concerning whether or not it's important or it's advisable to have a legal representation in a trial scenario, which I think is, because that's also very, very important to note. The quick answer would be, Felicity, and you can advise what your view on it. The quick answer would be no, it's not necessary if the case is quite simple. You're a salary earner, the father is a salary earner, minor kids, simple rent, accommodation, food, clothing, etc., well outlined. Simple. You do not need legal representation because the court has an obligation to inquire, to be very inquisitorial. And if you presented your information very well, you go on the witness stand, you stipulate, this is my income, undisputed. These are my expenditure, petrol, car, food, etc. Very simple. The court will be in a very good position to make a decision without legal representation. If, however, the other party is lying, is hiding assets which you know about, is being very clandestine, then my advice to you strongly is make use of legal representation to assist you in your matter, because if you do not make use of legal representation or good legal representation, the other party might get away with paying half what you are entitled to because he or she must pay a great amount. There is money available, there are resources available, but it's being denied. So with legal representation and with people like yourself as well, also Felicity, to do financial investigation and financial inquiry of somebody outside the court realm can assist somebody in being well prepared in court. For argument's sake, if this person only says, I'm earning a salary of, for example, I'm using round figures of 1,000 rand per month, done. But he does not disclose the money he receives on a monthly basis from a trust into his private banking account. So on 1,000 rand per month, yes, we accept maintenance of 100 rand per month is fair and reasonable. But had we had the data in front of us that there is a beneficiary of a trust that is earning another 1,000 rand somewhere else, obviously the amount would have been different.
Yeah, those are they're becoming more common, I need to say. Whether it's trying to get out of paying more maintenance or paying more tax, whatever it is. I mean, people have very creative ways of putting in a package together for their employees. And the Maintenance Act says income. It doesn't say salary, So often, and these are important things because the maintenance, and I've heard it said so many times where the maintenance officer says, no, he's only getting a basic income. We can't take his commission into account, or, these other income that he's making from his side hustle, whether it's DJing, whatever it is, because it's not regular. They're possibly getting it in cash or whatever, so it becomes difficult to prove. And you can, in a financial inquiry, get all of that information, and if you can prove that their lifestyle, for example, contradicts what they are presenting in court, then a legal representative knows how to put those arguments forward and highlight the parts of the Maintenance Act that often the maintenance officers are not 100% clear themselves or intentionally bypass to try and make the process get settled quicker, because, I mean, we know that they're overburdened. And then absolutely yes, because as I say, it's not just that amount, it's times 12 and possibly times 24. And I mean, even if it is like 1,500 Rand a month, over a year, it's 15,000 Rand a month that could quite easily, for example, save a motor car, or guarantee electricity and water, or extramurals for the child. So it's important to get the best outcome that you can. And if it means getting legal representation, then yes. And it's also relative, because unfortunately, for high earners where the maintenance monthly becomes a lot bigger, it's almost like a natural conclusion. However, I mean, if you take that case that you took on appeal in the Eastern Cape, it wasn't it wasn't like 20,000 Rand, but still that amount is significant for that client. It was 1,000 and 5,000, wasn't it? So and I mean, that's a huge contribution to the monthly budget every month, and even more so now post-COVID. Every 100 Rand has got to be stretched a lot further.
Yeah, Felicity, on the issue concerning the court case, yes, the magistrate made an order 1,000 Rand per month, and on appeal, clearly to the appeal courts, the High Court in Eastern Cape matter, but Pietermaritzburg, so Port Elizabeth High Court, clearly made an order of 5,000 Rand per month because evidence was there to support it. There was information and data there to support the claim, but it seems to me that some courts, and it's unfortunate, they got this preconceived view. In our courts, we do not give less than X, and we never give more than Y. Is this the way they work out the figures? So, and that prejudizes the parties, because the law says specifically you pay maintenance according to the needs of the child, the means of the party, etc. So there's no fixed amount of money which you have to pay. It depends upon the circumstances of each case. So I get very concerned. And Felicity, many times when clients do approach me for legal representation in a court matter, in a maintenance court matter, is because the they feel that the maintenance officer or the maintenance magistrate does not listen to them. And I understand that. I agree with that because I have that same problem, but the difference between me and the client is I hammer my case. I exhaust the magistrate. I fight because I'm a legal practitioner. I got a bit of backing. But they do not have that. And quite a few times I have to argue, and the magistrate tries to get me to agree with him. I don't agree with him. But the difference is if you're a lay person, you are technically forced to, or you're told to keep quiet, and they cannot tell a legal practitioner to keep quiet. That's not right. So those are the advantages when you have legal representation, but also you need legal representation that's willing to fight for you as well. So it's useless having a suit appearing on your behalf just to be there for the sake of being there and invoicing you and billing you. You need somebody to willing to fight for you. If that person is not willing to do that, fight for yourself.
No, absolutely. It's just the harsh reality is that the majority of complainants do require legal representation, but they just can't afford it and they go to court unrepresented, sometimes with disastrous results. It's a problem that we somehow need to change. One of my ideals was through the organization, if we got funded, to kind of start our own law clinic, just purely for maintenance matters. But maybe one day still, we don't give up on that. And, that's the one thing that my initiative of the Child Support Awareness Week, and so grateful for legal practitioners like yourself and many others that have bought into that, where at least you can get 30 minutes guidance from somebody who is knowledgeable and is kind of committed to the space. I wish we could do more, but unfortunately we can't at this stage.
Now, Felicity, those free consultations, I don't call it necessarily free. I believe, Felicity, the more people I consult with and engage with, I develop as well as a person. So that's also one reason I do these webinars online and have this Q&As, is that I know exactly what's happening on the ground level. Suddenly I become aloof and just want to appear in court all the time, but I do not know exactly what's happening down there. What are they struggling with? And suddenly that I also only advise on clients who are in front of me. They can most probably, for argument's sake, let's say 5 a month, whereby with these Q&As and what you are doing in your group, you are applying your brain to hundreds of cases every month, and that makes you a better practitioner as what you are doing. So Felicity, thank you very much for that. On another point, I want us to move away. I want the courts to move away. There's preconceived amounts which they have. If a man comes, and I'm being respectful to everyone, if an elderly man comes to the maintenance court and he makes a young girl pregnant, whatever the case may be, and appears in a certain type of maintenance court, they will actually, because they respect this elderly man, they will push this girl away and say, "Man, what are you doing here? This man is a respectful man." They will apply other concepts, other principles, nothing to do with the law, with preconceived views and prejudices and cultural norms, etc., and not apply the letter of the law. An interesting point which I thought about now is that if the same parties appear in the divorce court, in the High Court for child maintenance, in a Rule 43 application, a robust application, the chances of the mother getting much more money in the High Court in a robust application, in the sense of this is 2 affidavits and some lawyers are arguing, it gets finalized within a half an hour's time maximum. She'll get much more money than should she go in the maintenance court and spend a whole year there. Same parties, difference is there's much more data in the maintenance court that justifies the amount, where in the High Court, the court just basically, my respectful view, basically this, thumbs up based upon the data in front of them and makes a decision based upon the Rule 43, and that's how Rule 43 works. So Felicity, the government needs to come back on the table. The government needs to come to court with some advise the maintenance officers, please, you need to deal with each maintenance case on a case-by-case basis. So for argument's sake, Felicity, if you have a wealthy-ish clients in a poor rural area, the person who is supposed to pay maintenance will get away with murder. Because even if he must pay 10,000 Rand per month, because their policy is the most we ever give you is 5,000 Rand per month, you'll get away with 5,000.
Yeah, Mohammed, I've looked at the Australian model several times, and I really believe that we need to be moving away from a maintenance court and really looking at a blend of what we, our law and the Australian model. Because, if you consider the Maintenance Act says that maintenance comes before debt. So if your income is 15,000 Rand, okay, the variables, and I know they're a first world country and we're not, but that's what I'm saying, we need to find, in my opinion, a mix. Is if your income is 15,000 Rand and you do not co-parent, then the percentage you contribute needs to be higher. If you do have access and it's every second weekend, then you pay slightly less. And if you are, the more active you are, it goes down on a scale. But there needs to be a minimum amount of maintenance, in my opinion, absolute minimum, based on cost of living, minimum bread baskets, all of those factors, because of the loophole and what historically how the maintenance courts have operated is I'm unemployed, or they intentionally resign out of spite to not pay maintenance. And there needs to be a minimum amount of maintenance so that it's a deterrent, that irrespective of whether you're working or not, that there's an absolute minimum. And I'm saying that mindful. So when I say minimum, based on other factors, like a minimum would be 500 Rand a month, whether you're employed or not. Because if you're unemployed and you are still alive at the end of the month without getting an income, then you can make a plan for your kids. Because if you're not, somebody else is having to pick up the slack. And the social grant of 460 Rand is completely inadequate. And I mean, I don't know if you've seen my post again, because I keep posting it, with the abject-based food poverty line of 571 Rand, and that was like a year ago, so it's probably changed because of inflation as well now. It just, in my mind, I think the state is failing children by just letting people use the excuse, I'm unemployed, and sometimes it's legit, and I know there are many people, even with high qualifications, with tertiary education, that are battling, they stay without jobs for 5 years. But then if it becomes a norm that there is no excuse for maintenance, I think that there's less opportunity for manipulation, because it's just not negotiable. For me, it's this whole accessing maintenance court for I'm talking generally, because the Australian model is for your normal, it's done actually online. I mean, you can't have, their tax system is amazing. They don't have as big an informal sector as we do. I don't know what the blend is, but I do believe that if we were creative enough, we could find what the blend is between their system and ours. It's just, I cannot comprehend how our authorities just go, well, shame, he's unemployed, but the mothers or the primary caregivers are also unemployed, yet they're compelled to ask family members or seek whatever relief they can. And I think that burden of responsibility needs to be shifted in some way, more equitable between both parents, without it being a court process.
Felicity, well said, well said. That's something which I've also been advocating for many years now. The sad reality is, Felicity, is even if the mother can afford, for argument's sake, to maintain the child, and the father is paying the bare minimum, what is it meaning? That every month she has to limit her needs. Now she will have no savings every month because all her money goes to the minor child, where the father, on the other hand, or the mother, I'm applying to caregiver and second caregiver, but in my scenario, with the father, on the other hand, he can develop himself, he can, build an empire, keep a lot of savings, etc. Because all that he knows is I'm paying this bare minimum to the mother, which might be 10% of my income, but the mother has to pay 50% of her income towards a minor child. It's blatantly unfair, and there seems to be a prejudice of a certain stereotype that mothers are left to bear the brunt of caring for children. And it applies to child custody matters as well, Felicity, whereby the law enforces a father's right to have contact in terms of a court order. So the mother can be locked up and jailed for not allowing the father contact and care in terms of a court order. But at the same time, if the father decides, no, I'm not exercising contact this weekend, despite the court order allowing me to do that, nothing will happen to the dad. So the mother should have the child ready at the doorstep at 2 o'clock on a Saturday afternoon with the child, backpack filled up, etc. Father can just WhatsApp the mom, sorry, I can't make it, or you can run late. So the mother still bears a brunt of this injustice and this gender stereotype. It's very unfortunate.
It is, and I mean, it's like one of my things that I've spent so much time creating awareness is the absolute impact that this inequality has on mainly mothers. And so if you responsibility it just seems so easy to be able to abdicate responsibility on the assumption that the primary caregiver will just keep picking up the slack, whatever that slack is. It's like you can't force somebody to co-parent if they don't want to co-parent. And then there's this mindset, well, I'm not co-parenting, so why should I pay money? So while they're legally two separate things, they're pretty intersectioned and they have a direct bearing on each other. And as you say, if you don't, if the other parent doesn't come and exercise the contact time, it's okay for them to not, and they can, this thing where they go, well, I want next weekend, whether it impacts on the primary caregiver schedule or not. And then if you don't, then you're accused of parent alienation or frustrating access or being difficult and unreasonable. But, you know, there's the other impacts. So parents are, you know, probably meeting new people or the opportunity, going out, socializing with friends. You have a weekend off and you make all these arrangements and suddenly they cancel. And then you find out, well, that person went out to socialize. So it didn't suit them, but it impacts on you. While your priority is your children, that's where the irritation and the niggling bits start creeping into this. And the same with maintenance. They can just go, sorry, I'm not paying this month. And the process to enforce it is so arduous because you go and go, oh, well, he hasn't paid. You go make your application and then suddenly he pays before the next day. Okay, so well, then now it's kind of resolved. Or you get a date and it's 3 months down the line. Then you get issued a garnishee order, but they don't back pay the garnishee order because the garnishee order now takes 2 months to become effective. So essentially you've gone 5 months and then they go, oh, well, I'll pay you a few rands a month. I can't pay you a lump sum. I mean, there's just so much that doesn't work properly. I really think that there needs to be a way that it's simplified. You do it or there's consequence. Simple. We have to start getting to that point. And, you know, much like, so if you're going to co-parent, and that's what I say to parents, you know, keep a journal. Keep a journal, or if this is, you know, regular behavior, because you do eventually have recourse. Yes, I know that we're wondering a bit, but then you can approach your legal representative, or you can, you know, go to mediation and go, here it is. This is not emotional. Here is the fact. Here are the records. He paid me maintenance on, yes, he's paying every month, but he's paying on the 7th, 8th, 9th, 10th, and all my debit orders bounce. He says that he'll fetch the kids at 6 o'clock, but he comes at 9:30, or she comes, you know, these kind of things. Keep a record of this because you do have recourse. It is not okay. But if we don't put boundaries in place with those things, whether it's personally or legally, it's always going to happen.
Felicity, thank you for that, Felicity. I'm with you. You know, I'm a full supporter of that argument. There needs to be boundaries, and the government needs to start. You know, Felicity, I'll go back to the same example I mentioned earlier on a previous webinar. COVID-19. Government put their foot down. Beaches are empty. Businesses are closing. It even caused the collapse of our economy because government put their foot down. Here we're dealing with something regarding, children being fed, life, our future of our country. And it seems to me the government is very apathetic. They're willing to pay the SASSA grants, but not willing to do much about the problem we have. Felicity, let me just hold you for 1 second. We have a comment. It says, "Hi, Felicity and advocate. But some fathers only want to pay for food only. And what about the rest of the minor child's needs?" The rest of the needs obviously would be, schooling, clothing, accommodation, and so on. So that's the reality. Felicity, we passing the 40-minute mark. I do not want this video to go past 50 minutes because it will be elsewhere. Any comments, final comments, Felicity, or what you can deal with?
I think that one, my belief that the retractable challenge is that there is no political will. And in our awareness and in our advocacy, and I do it consistently, but we need to start expanding the pressure put on the politicians to actually start taking this seriously, because they're the ones who run their ministries. But I believe that whichever political party actually pushes this as a main feature will kind of be committing political suicide. Because if you go onto the threads, I mean, some of the threads, I literally just like shake my head, because I go, this is why we are in the mess that we are. Because, it starts from the top and the bottom. It doesn't just filter down, it's top and bottom. That there are so many social norms and social constructs that are just wrong. We have to rewire our brains, literally rewire our brains in terms of what our responsibilities are as parents, our obligations, so that we can raise a healthy next generation.
Well, listen, if you run for a political party, I will definitely vote for you. I'll canvass for you.
Thank you.
I think maybe with a child maintenance awareness, it will get your foot into the door. But whether or not you become go further, I think then political challenges will come about. Felicity, and it saddens me because we know there are millions of people in South Africa and thousands of maintenance problems. And then Department of Justice will come and say, no, we've appointed so many. Felicity, it doesn't make sense. I mean, if you have 1 million people, you can't appoint another 50 people. It will make no difference at all. It won't. So that's very saddening. Felicity, from my side, I think I see a lot, and I've learned a lot from you, as I always do. I think we can just keep on lobbying and go forward. But Felicity, before I end off, we discussed this issue now, and myself, as a legal practitioner, I might be an advocate and do a lot of family law matters, but I do not have the skills and the resources to do maintenance investigations and to equip certain people with certain tools and things out there that is very useful for people in a child maintenance matter. Everyone coming to my office, many people that come to my office, half of them could possibly not require my service as a legal practitioner, as an advocate, but could require the services of somebody that understands the law, can coach them, can obtain information from them, for them, and assist them in the maintenance process. So for argument's sake, a lawyer might charge, for argument's sake, 1,000 rand for a court matter, but what if the client spends, for example, 100 rand to assist him in a matter and get the same results? So that's where you come in, Felicity. You offering certain services, certain products. Please educate me on it. I want to learn.
Yeah, so I would say 80% of my sessions go beyond just the framework, the legal framework or court process or how to fill in documents, because a part of it is understanding what you're up against. And I mean, we need to understand the context. You spoke about it earlier, the bias of the people that are there. Understanding that is quite an important aspect. The other one is emotionally. I prep them emotionally how to conduct themselves in court. A lot of them the night before they go to court, we do a quick prep talk, but it's and most of them last about an hour. That it's also it's a connection with somebody that gives you a little bit of confidence. I'm able to give them certain sections, because there's some very basic sections in the Act, for example, maintenance before death. all children should be treated equally. When I say that, not equal amounts, but pediatrics children, all these school fees need to be considered the same, not 4 kids and the 2 don't get school fees paid. So these basic fundamentals that are overlooked, and I give them those and the five basics that are the essentials, and then also how to deal with the extras, the extramurals. But it's the key words that they're able to stand their ground, and also go, sorry, I don't accept this. I like to go and see the magistrate, or I'd like to get a legal representative, because they know what their rights are, they know what they're entitled to ask for. And also to have the confidence then to go, sorry, because this one maintenance officer told a client of mine, no, he's paying medical aid and that's enough. He doesn't have to contribute towards anything else. And she's going, what about all the other 4 aspects? And she goes, no, you don't understand the Maintenance Act. She says, I do. Here it is, So it's saying, okay, well, then I want to go to the magistrate. Or if you are treated poorly, you know what recourse you have. We have far more power than what we actually think we have. And we are their clients. And if you know what to expect as a client, then you know how to. It's like going to a supermarket. You complain to the manager. You're a client there. That's what I coach my members, that you have the same attitude when you go to court, so that you respectfully, it's like, if you don't mind, sorry, with all due respect, can we have a look at this section? It's not, you don't know your job kind of thing. So it's those kind of nuances that really make a big difference when somebody goes to court. And it's a very small fee of 400 Rand, which is really, in my opinion, I should charge more. But, I'm trying to make it reasonable and affordable for most people.
Now, Felicity, on the fee part, many legal practitioners who do not have experience as half the experience you have, the valuable, workable experience, will charge something maybe minimum, maybe 1,200 Rand for an hour, where your one is a third of that amount, and they're getting much more value for their money. That's minimum, and some lawyers will charge 2,000 Rand per hour. So, Felicity, thank you very much for that. On the screen, Felicity's details are there. Her email address, felicity.cmdsa@gmail.com. She is quickly available. You email her now, she'll get back to you very soon thereafter. And of course, Child Maintenance Difficulties of South Africa, the Facebook page, but the email is available. Please connect with her. I might even ask you the question, how do you know about me? You came to my office, you say you watch my webinars with Felicity. I'll ask you the first question, have you first seen Felicity? Because if you first saw Felicity and consulted with her, our dialogue will be much more different. So you paid her 400 Rand, you'll save much more money with me, because we can consult maybe 2 hours less now, because Felicity unpacked it with you in a very practical manner. Felicity, thank you very much for that. Felicity, our time is up. The video is ending soon at 50 minutes. Any final comments, goodbye comments before we log off?
Yeah, no, it's just that, thank you always for being so willing and for what you do for women and for children and for fathers and co-parenting and for maintenance. Thank you.
Welcome, Felicity, and saying thank you to you. Felicity, I think we have an obligation to society, certainly, that we hold all this knowledge and this information in our brains, and we cannot assist, because if we do one webinar, a few thousand people watches it, and they learn, and if only 10% of the 1,000 people, few thousand people learn something and benefits from it, wonderful, we've done something great, as opposed to just keeping this data in our brains. What's a succession plan? We need a succession plan. Felicity, please stay on the line. Maybe in this video on Zoom, I'll keep the Zoom alive. I'll edit on Facebook Live. Stay online. I'll chat you now. But thank you very much. And thank you to all the viewers. Thank you for the commenter. I'll see you online soon. Thank you. Bye-bye.